Every mainstream outlet reported Friday night's Supreme Court order as a Republican loss in Pennsylvania. Every single one. And every single one missed the actual story. 3 justices, Alito, Thomas, and Gorsuch, wrote separately after the denial. And what Alito wrote is not a disagreement. It is a blueprint. It explains precisely why the court could not act in this specific case, and precisely what case structure would allow them to act next time. When 3 Supreme Court justices take the time to write separately in a case they just denied, they are not walking away from the constitutional question. They are marking exactly where the next battle will be fought. I'm Michael from Gun Guide Pro, 10 years in constitutional law and firearms rights. And the Pennsylvania election battle did not end Friday night. It just entered its most consequential phase. Before we go any further, must subscribe to Gun Guide Pro right now and turn on every single notification. We are a new channel building something genuinely important here. Real constitutional analysis without spin and without partisan theater. Post-election lawsuits are already being structured based on what Alito just wrote. New cases are filing right now. When emergency orders drop, you need to know within minutes. Every subscriber tells us this content matters and gives us the motivation to keep delivering this level of coverage. 2 seconds. Completely free. Hit that subscribe button. Hit that bell. Let's get into exactly what Alito actually said and why it matters more than the denial itself. Let me walk you through the actual legal question, because understanding it is what separates informed citizens from people who read a headline and think they know what happened. In Pennsylvania, mail-in ballot voters must seal their ballot in a secrecy envelope. That goes inside a second declaration envelope that must be signed and dated. If the ballot arrives missing the secrecy envelope or improperly signed or dated, it is flagged as invalid. The voter is notified and can cast a provisional ballot at a polling place on Election Day. The question that reached the Pennsylvania Supreme Court was constitutionally explosive. If a mail-in ballot is received on time but invalid because of technical errors, must the provisional ballot that same voter cast on Election Day be counted? Pennsylvania's Supreme Court said yes, 4-3. If the mail-in ballot cannot be counted, the provisional ballot must be. The RNC challenged that immediately. Their argument was precise. The Pennsylvania legislature specifically wrote language saying, certain ballots shall not be counted. 2 words, shall, not. The clearest mandatory language in statutory drafting. A state court cannot take shall not and rewrite it to shall simply because it believes a different outcome is more fair. Courts interpret laws. They do not rewrite them. Drop your state in the comments right now. Are you watching from Pennsylvania or another state where this exact question, whether courts can rewrite what legislatures specifically wrote, is currently active? I personally read and respond to every single comment on this channel. Here is the part every outlet missed, and it is the most important part of this entire story. The Supreme Court denied the emergency request, but Alito's statement explaining that denial does not read like a court that thinks Pennsylvania got it right. It reads like a court that could not act, for one very specific procedural reason, and wanted every election law attorney in America to know the difference. Alito's statement is surgical. The original case involved only 2 voters with provisional ballot issues during the 2024 primary election. 2 people. 1 county, Butler County. The only Pennsylvania officials who are parties to this lawsuit are election board members of that one specific county. Because of that narrow structure, any order the Supreme Court issued would only bind those specific officials in that specific county. It cannot create statewide obligation on any other Pennsylvania election board. Cannot change how any other county handles these ballots. The relief the applicants wanted was statewide. The case structure they brought only supported county-level relief. Alito states it explicitly. Even if he agreed with the constitutional argument, he could not prevent the statewide consequences the applicants feared. The case was structured too narrowly to give the court the legal vehicle it needed. Read that with precision. Alito is not saying Pennsylvania's Supreme Court was right. He is saying this specific case could not produce the remedy needed. Those are completely different statements, and the distinction is everything for what comes next. Which politician in your state do you think has been most aggressive about using state courts to create election rules that state legislatures specifically chose not to write? Name them in the comments right now. Here is the legal argument that Alito, Thomas, and Gorsuch did not dismiss, and why its survival matters enormously for every future election. The Elections Clause of the United States Constitution is explicit. State legislatures not state courts, have the authority to regulate federal elections. That is the specific constitutional provision the RNC invoked, and it is a provision the Supreme Court has never definitively resolved. The argument is this. When the Pennsylvania Supreme Court rewrote the rules governing invalid mail-in ballots, creating a provisional ballot remedy the legislature specifically chose not to include in the election code, they crossed a constitutional line. Courts interpret laws. They absolutely cannot create ballot-curing processes that the legislature deliberately excluded. The three dissenters in the Pennsylvania Supreme Court agreed. They said the election code language is unambiguous. The legislature used shall not, the strongest mandatory language in statutory drafting. A state court has no authority to turn that into shall by reinterpreting intent. This constitutional argument, that state courts are usurping the legislature's constitutionally assigned role in regulating federal elections, has been building through election law cases for years. Based on Alito's statement Friday night, it is not resolved. It is waiting for a properly structured case to give the Supreme Court the vehicle to answer it definitively. What is your honest prediction? Will the Supreme Court ultimately rule that state courts cannot create election remedies the state legislature specifically chose not to create? Type, legislature controls elections, or courts can interpret broadly in the comments. I want genuine constitutional analysis from this community. Here is the realistic picture of what happens from here. Because Friday night's denial is not the end of this story. Based on what Alito wrote, it may be the most important beginning. The fundamental constitutional question is completely unresolved. The denial was based entirely on the narrow procedural structure of a two-voter, one-county case, not the merits. That distinction creates an open door that election law attorneys are already walking through right now. Expect new lawsuits, broader ones, structured to include enough Pennsylvania election officials across enough counties to give the Supreme Court the statewide vehicle Alito said was missing. Election law attorneys on both sides are reading Alito's statement line by line right now, figuring out exactly what case structure would satisfy what the court said it needed. Expect post-election challenges if Pennsylvania results are close. Election lawsuits multiply when margins are narrow. With the provisional ballot constitutional question completely unresolved, any close Pennsylvania result creates immediate litigation pressure using exactly the framework Alito just described. And expect this question to reach the Supreme Court again. The three-justice statement signals that at least some members of this court believe this question deserves a definitive answer. They just need the right case. And Friday night, they told the legal community exactly what that case needs to look like. Do you think Pennsylvania's results will be close enough to trigger post-election lawsuits based on these unresolved provisional ballot questions? Type, too close, lawsuits coming, or margin will be clear in the comments. Here is the connection most people watching this channel need to understand. Because the Pennsylvania election case and your Second Amendment rights are fighting the exact same constitutional battle. The Elections Clause question is this. If state courts can override clear legislative language by reinterpreting election rules, then the constitutional assignment of election authority to state legislatures becomes meaningless. Courts become the final authors of rules rather than the branch the Constitution assigned that authority to. That is the exact same argument gun rights organizations are making in dozens of active Second Amendment cases right now. When courts uphold gun restrictions in direct defiance of what legislatures authorized and in direct defiance of the Bruen standard the Supreme Court established, they are committing the same constitutional violation the Pennsylvania Supreme Court committed here, substituting judicial preference for legislative authority, rewriting what elected institutions specifically chose to write. Every time the Supreme Court reaffirms that constitutional authority belongs to the institution the Constitution assigned it to, it strengthens every challenge to judicial overreach in every area of constitutional law, including Second Amendment cases, including Bruen challenges, including every ATF regulatory overreach case currently pending. This is not a partisan question. It is a structural constitutional question about which institutions have authority over which decisions, and the answer the Constitution gives is clear. Elected legislatures, not courts rewriting what legislatures specifically chose. Here is what you do right now. First, subscribe to Gun Guide Pro and hit that notification bell immediately. We are a new channel, and every single subscriber gives us the motivation and resources to keep covering these constitutional developments at this level. New election law cases are filing right now, and you need to know the second they drop. Second, smash that like button and share this video with every constitutionally minded person you know. Most people have no idea what Alito actually wrote or why it matters more than the denial itself. Third, answer all 3 questions in the comments right now. What state are you watching from? Which politician in your state has been most aggressive about using courts to override legislative election rules? And what is your favorite constitutional ruling of the last decade? Bruen, Heller, or something else? I personally read and respond to every single comment on this channel. Gun Guide Pro is just getting started. The constitutional battles coming over the next 12 months will define American law for the next generation. Be here for every single one. Stay informed, stay armed, know your rights. I'm Michael from Gun Guide Pro. See you in the next one when the next emergency order drops.